There's an open seat on Nevada's Supreme Court, and we're talking with one of the candidates, Judge Jerry Tao. Welcome to Nevada Politics Today. I'm your host, Victor Jakes. Judge Tao currently sits on the Nevada Court of Appeals, and now he wants a spot on the Supreme Court. He's running for an open seat against Judge Elisa Kadish. Judge, welcome to the show.
Thank you. Good to be here. Thanks for the opportunity.
Well, let's start with your judicial philosophy. You've moved from a court where you interpret or follow the precedent to setting the precedent. How would you describe your judicial philosophy?
Well, as you mentioned, I served for many years on the district court here in town where I didn't really have to have a strong philosophy. I'm on the Court of Appeals now where we do have to have one. Last year, Neil Gorsuch was appointed to the U.S. Supreme Court, as everybody knows, and he has a saying that he is the first avowed originalist and textualist to ever serve on the United States Supreme Court. If elected, I would be the first avowed originalist and textualist to serve on the Nevada Supreme Court. And honestly, I think it's about time that we had somebody like that. Some of the rulings that the Nevada Supreme Court has issued in the past have been a little bit loose on the law and the Constitution, and I think the Constitution should be strictly and narrowly construed.
And what are some of those rulings that you've thought maybe strayed a little bit from the original meaning of the Constitution? Well,
there are a couple of them. The most famous one is Gwynn versus Legislature from about 15 years ago, where the Nevada Supreme Court basically had one provision of the Nevada Constitution overrule another. Another one was a case involving a family law case called Landreth versus Malik, relating to the jurisdiction of the family court system. And in that case, it was a 4-3 decision. The dissenting opinion was written by Justice Douglas, now Chief Justice Douglas, and he basically pointed out that what the majority had done was resurrect a ballot question that the voters had actually rejected at the polls a couple of years ago. On my court, I've got a smattering of dissents that follow the same principle. There's one called Ibarra versus State, where I think that my colleagues on the Court of Appeals misinterpreted one of the statutes a little bit, and I wrote a dissent explaining why we need to be faithful to the words of the statute and the Constitution and not our own personal policy preferences. We're elected to interpret the law and the Constitution, not to impose our views of the law on people, not to legislate from the bench, is the saying that everybody uses. And I think we have to be very careful when we wander into the policy arena.
So you compare yourself to Neil Gorsuch. 20 years ago, your background, you were writing speeches for Harry Reid. How do you go from Harry Reid's speechwriter to imitating Justice Gorsuch?
Right. Well, I did work for Harry Reid, and it was a good job. I'll never say otherwise. But when you're working on staff for somebody, you don't have to have a judicial philosophy. I wasn't a judge then. Even for many years thereafter, when I practiced as a lawyer, I was a DA for many years. I was in private civil practice representing small businesses. I didn't have to have a philosophy. My philosophy as a lawyer was whatever is best for my client. That's the philosophy I'm going to advocate. But since being on the bench for the last 8 years, I've developed one. Now I have to have one, and I've spent a lot of time thinking about it. And this is the philosophy that makes the most sense to me, and that I think is the most true to the vision of our founding fathers.
The NRA doesn't get involved in a lot of state judicial races, at least not in Nevada, and they've endorsed you over your opponent. How did you earn the NRA's endorsement?
Well, honestly, I think it comes down to my view of the Constitution. A lot of people don't know this. The Second Amendment to the U.S. Constitution gets a lot of attention. That's what everybody talks about with some of these U.S. Supreme Court decisions. Our state Constitution is actually much more protective of the individual right to own firearms than the national Constitution is. And so by being faithful, so what the NRA cares about is judges who are faithful to the Constitution, who are going to implement it as written, as our founding fathers envisioned it, and not impose their own policy preferences. You may like guns, you may dislike guns, but it's not your job to change the Constitution, and our Constitution is much more protective than the federal Constitution is.
I want to go to graphic one, switch gears here. Someone's filed a complaint about this election, specifically about how you've been describing your opponent. The Nevada Commission on Judicial Discipline is investigating whether state Supreme Court candidate Jerry Tao improperly used partisan language in a campaign flyer and on his campaign website. Complaints to the commission are not disclosed publicly unless action is taken, but Tao says he received a call this summer from an investigator who asked about the campaign materials, which included terms such as left and liberal. Is that appropriate for a judge to describe their opponent in those terms? Well,
first of all, let me be clear. I never described my opponent in those terms. In fact, if you look at the flyer that was the subject of the complaint, what I'm talking about is judicial philosophy, your very first question today. I never called my opponent a registered Democrat or Republican or Libertarian or anything like that. My statement was the Nevada Supreme Court has a certain point of view which can be described as liberal. Loose constitutionalism, non-strict constitutionalism is generally called a liberal point of view. People talk about the U.S. Supreme Court. There are liberal justices, conservative justices. It doesn't necessarily mean they're Democrats or Republicans. In fact, famously, Earl Warren, who's accused of being one of the most liberal justices in the history of the U.S. Supreme Court, was a registered Republican. So when I say liberal and conservative, I'm not talking about party registration. I'm talking about what is your judicial philosophy. I'm glad you brought that up because the complaint is actually frivolous. I responded to the complaint with a long letter from First Amendment experts who pointed out this is a frivolous complaint because it is completely mischaracterizing what I'm saying and even what I'm saying to you now. I'm not saying my opponent is a particular party. I'm saying that she and I have different judicial philosophies, and I think that's a valid point to make.
And I think it kind of goes to a tension where you're ruling from the bench as a judge, but you're also running for office. Should judges be appointed and then maybe retained by voters instead of having to be elected?
Well, it's a valid point. Things like this. When you have judges running for office, things like this ethics complaint can become campaign stunts. In fact, you called it an investigation. It's not even technically an investigation. Someone associated with my opponent filed a complaint. The next step is for the Ethics Commission to vote on whether there will be an investigation, and they haven't done that. So what people do now is they launch this complaint, they get a buddy of theirs to launch a complaint, then they go out in the campaign trail and say, my opponent's under investigation, and it's all just, I don't want to use the word fake news, but it really is. It's generated just to create news, and what it does is it makes judicial elections like every other kind of election. Let's just throw a bunch of mud around and see who wins, and it doesn't have anything to do with whether I'm a good judge or whether my opponent is a good judge.
Well, I mean, isn't that kind of inevitable if there are elections? Would we be better off served if it was a different system?
That's the best argument in favor of it. That the judicial election process shouldn't be as politicized as it unfortunately has come to be. Judges should be above the law. I'm a registered nonpartisan. Judges should be above politics, not above the law, above politics. Right. Because we don't rule on things as Democrats or Republicans. We call, as Justice John Roberts said, we call balls and strikes, and that doesn't depend on our party affiliation. But when you have judges elected, you invite things like what my opponent has done: throw around mud, and maybe it'll stick, maybe it won't. Hopefully, the voters will see through it, but you never know.
Well, one part of the Constitution that's been kind of overlooked is the separation of powers. Republicans have long complained that public employees serve in the legislature, and the state Supreme Court has basically tried to punt that question away. Is the separation of powers an important part of the Constitution?
I think it's a vital part. There's a very famous story involving Justice Scalia, where he used to teach his students before he was on the bench and was a law professor, that one of the tragedies of American judicial history is that the Warren Court back in the day used to overlook the separation of powers aspect of the Constitution in favor of individual rights in the Bill of Rights. And the problem with that is separation of powers is really how you guarantee that the United States will never become a dictatorship, because no one person has all the power. It's divided among three co-equal branches. When you blur that, you almost invite the possibility of a dictatorship when too much power is accrued in the hands of one person or one small group of people. And I think that our law has reflected that gap, where sometimes, Justice Kavanaugh's confirmation hearings last month and then Justice Gorsuch's last year, that was a big issue. Separation of powers, the administrative state. Who actually runs agencies like OSHA and the EPA? Who are they accountable to? And are they actually exercising the powers that the Founding Fathers wanted them to have, the limited powers that the Founding Fathers wanted them to have?
And another check on the government is with public records, and the Supreme Court, state Supreme Court has been pretty good historically on public records cases. Last week ruling in a 4-3 decision that the public has access to PERS records. How important is it that the public be able to view records?
I think it's critical. You mentioned, for example, the people who are contributing to my opponent's campaign. One function of democracy, there are a couple of components of democracy. One is separation of powers, one is free speech. You should be able to debate things. That's why that ethics complaint that we talked about was so frivolous, that if we can't even talk about what's wrong with the court system, then what are we going to talk about? And the third aspect is the public needs to know. The public, voters have to be informed in order to make intelligent decisions. All three of these things go together: transparency, free speech, and separation of powers. They all go together in how voters make decisions, and especially in low-level races like judicial races. As you know, we don't raise millions of dollars. We don't have TV commercials every commercial break like we're seeing in this campaign cycle. And so voters need to be able to find the information they need to vote in every race from the beginning of the ballot to the end of the ballot.
And we're going to have to leave it there. Judge, thanks so much for coming on.
Thank you again.
And thank you for watching. Remember, if it involves Nevada politics, we're talking about it right here on Nevada Politics Today. I'll see you next week.